Today's courtroom is packed with tension, confusion, and a few surprising turnarounds. From rejected plea deals to emotional confrontations, this hearing has everything. We've got Judge Coleman presiding, a nervous defendant facing a life-altering choice, and a bond situation that's about to take a shocking twist. Stay locked in, because what starts as routine quickly spirals into an emotional and legal roller coaster you won't believe.
Okay. All right. Good morning to the class that's here. How are y'all today? Good. I'm glad you're here. Okay, let's see. Well, we don't have... I know. I like it. I don't know why I was hurrying so much.
That's what I said. We've got some rejections and Alex has one release.
See, Mr. Parker, you have Tyree Hartley.
I was just talking to Martina about that, Judge. He has some cases all over the state, and I think they just resolved one in Fort Bend where he got 2 years, and we could have like a couple weeks to. I think there's another issue with the
Co-defendant is set for a bond hearing today, Your Honor. I think it's best if we kind of see where that goes, see where they go, get some of their other things resolved. It's definitely a plenty of time off.
Okay. All right, I'll just do maybe 3 weeks or so. Well, no, let's just do a normal reset. Yeah, okay.
Thanks.
And Asa Jones.
I have a rejection on that.
Asa Jones, yes, please. Morning, Mr. Coleman. Good morning. Are you Asa Jones? And Mr. Jones, in cause number 25 DCCR 0963. My computer's going slow. Give it a minute. You're charged with a first-degree felony offense of aggravated assault by discharging a firearm from June 12th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 5 years in prison up to 99 years or life. Do you understand? Answer out loud, please.
Let's pause right here. This is a huge decision point. The judge just laid out the stakes crystal clear. Asa Jones is rejecting a 15-year plea deal for an aggravated assault with a firearm charge. Now that's bold, considering he's staring down a possible life sentence. But here's the twist. Once that offer expires today, there's no going back. Do you think he's confident in his defense, or just gambling with his future? Let me know what you'd do in his place down in the comments.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for 15 years in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that? And do you want to reject that offer and have your case set for trial? I also want to make sure you understand, Mr. Jones, that after today, unless there's some new evidence that the assistant district attorney or your attorney gets or finds out, that this offer will not be accepted after today. Do you understand? Okay. And so, Mr. Jones, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial probably a little quicker. Is that okay with you? All right, Mr. Parker, you're released. Mr. Jones will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Carl Leday, Mr. Parker.
If I could have a moment, Judge, he was
I'll
not
hold
at the
him.
jail, so I need to talk to him.
Sure, I'll hold that. And then Perry Robertson,
We're about to, I have a new offer I need to sign.
I'll hold that as well. And Kaylin Welcome,
I believe that's a rejection based on what he told me.
I'll hold it as well. All right, I'll let you work on all those.
Sorry.
No, you're good. Oh, do you want to deal with, what do we have?
There's a,
State's motion to increase a bond. Do you want to get these others taken care of, or do you want to?
I think we can do it now. I mean,
Stephen Boudwin,
yes, ma'am.
come up, please.
And Judge, I have several things.
Now that's interesting. The judge just released Jones's appointed attorney right in open court. That doesn't happen often unless the court feels the case needs fresh preparation or a faster push toward trial. It shows this court means business. No delays, no excuses. It's all about momentum now. Imagine being Jones, suddenly losing your lawyer right after rejecting a 15-year deal. Pressure's on, and the clock is ticking.
Sure. All right, so you're Stephen Boudwin?
Yes, ma'am.
And let me get this pulled up. Is it,
And so if I can,
hold on just a
Okay.
second. Let me just get it, get what I need to, and then I'll let y'all. Oh, this was, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to your honor about
Yes.
on Friday. She bonded them out.
she actually, I wasn't sure about this. When I first, he called me yesterday and, about a bond here. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case. And we were waiting on a PSI, and we were looking at, we were gonna see what happened with parole. I think he's been released from parole. The parole hold's been lifted. No response. And then I get a call from her, and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about.
This is where the emotional tension hits hard. The prosecutor just revealed that Tiffany Guillory, the alleged victim, was in tears, terrified of the defendant, and begged for a bond increase. But now, she's the one who posted his bond. That's a complete 180. The courtroom's power shifts instantly as it raises a big question. Was she pressured, conflicted, or forgiving? Whatever the reason, it puts the judge in a tricky position. How do you enforce safety when emotions override fear? Drop your thoughts below. Is this compassion or confusion?
About the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was
I
forwarded
have it.
to me. And I told him that he needed to go and contact the probation department and do a PSI. I mean, I just told him yesterday, I don't know if he's contacted him yet or not.
Yes, they scheduled me to come in today, so I'm coming off the court.
Ms. Malfino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend, and I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time your honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday before I talked to you, Judge, and they were going to lift the hold, so that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously, and so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Boudwin, I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she wouldn't bonded you out. She's written me a letter. At this point, I don't care about any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person, that's through your phone, that's through sending messages. Again, she cannot say, it's okay, I won't tell. If something happens and she changes her mind again, which is likely it sounds like, and contacts Ms. Malfino and says, okay, I thought it was okay, but now it's not, he's coming around, you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. You have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay, okay.
All right, okay, you're free to go.
Thank you, Judge. I just felt it important to document the
I
record on that.
totally agree. Thank you, Ms. Malfino. Maybe I'll make some notations just based on all that, yeah. Morning.
Morning, babe. Could you not do it?
And there it is. Judge Coleman draws a firm line. No contact, no communication, no exceptions. The ruling makes it clear, even if Tiffany tries to reconnect, any violation means instant jail time. This decision isn't just about law. It's about protecting boundaries and preventing a cycle of emotional manipulation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal insights. Until next time, stay sharp, stay curious, and keep watching the truth unfold one courtroom at a time.